Hey, good morning, everyone. Welcome back. Good morning, Luttrell. I hope we didn't leave you hanging yesterday. The bronchitis bug struck Mike, and of course, I lacked the technological ability to plug in this computer and figure out how to do it on my own. But for Mike, I'd be talking to the wall instead of to you. Hey, we've got a new riff on an old theme today. How many times did you go to school in grade school or junior high or high school or college or law school or graduate school or a continuing legal education program, and you hadn't done the assigned work and you were worried about it and you needed an excuse? What was the excuse? My dog ate the homework. Well, we've got a new one out there now for you, those of you who are out at 3 o'clock in the morning in your supercharged sports car doing 140 miles an hour in a 55 or make that a 70-mile-an-hour zone. My dog was sick. I'm having a dog emergency. What's up with Jordan Addison? And I guess what I really want to know, Mike, is what's he driving and what in the world is going on?
It's a Lamborghini Urus, which is what Lamborghini brands as its super sport utility vehicle. Get this, man. It's practical, but also supercharged. It's a twin turbo. It's a 4.0 liter twin turbo V8. And I think they've been around for several years now, but it's Lamborghini's pivot into sort of the, I guess, society's preoccupation with sport utility vehicles, which I think is a great move. But we're not going to sit here and pretend like, Jordan Addison bought a Lamborghini Urus to truck his dog around and go hiking,
How was this in Minnesota that he was caught speeding, or what?
It was. Yeah, he was pulled over, and I've got the statement here if I can find that, but he was pulled over by the equivalent of the Minnesota State Highway Patrol, and this is around just after 3 a.m, and he was let off with a citation for reckless driving.
Well, here's the thing that stunned me. I mean, I don't know anything about Minnesota law. If we've got any Minnesota lawyers on here, chime in, educate us. Reckless driving in many states is a felony. And, you can speed, and that might be a misdemeanor. But when your speed gets beyond a certain point, it's more than sort of a casual failure to observe the speed limit. It's placing yours and the lives of others at risk. In 140 miles an hour generally meets that threshold. The rule, Connecticut, it's like 85 miles an hour. We're a 65-mile-an-hour speed limit state. It's so small it hardly takes any time to get from one end of it to the other. But if you're out there doing a $140, you're getting charged with a felony, and you're not winking your way out of that. So I'm thinking this was a little NFL justice. I'm not sure I don't know where your head is at.
Yeah, absolutely. I think the state trooper likely recognized who he had stopped, and is getting a little bit of home cooking now. I don't want to spend too much time, parsing the merits of law enforcement discretion, but I think we can all agree that this is definitely one of those de facto 2 tiers of justice in America. And I know we have a number of viewers who are of a certain age and were coming of age during the era of American Muscle. So I think we can all take a break and just respect the fact that a 21-year-old, he turned 21 in January of this year, and he was the 23rd overall pick to the Minnesota Vikings. And this is interesting. I think I put this tweet up on Friday. I think right after the stream is when all this stuff started kind of breaking, and I sent it to you, and I just threw a tweet up that said running 9 routes in the Lambo. 9 routes, just a go route. And this is, I think, in terms of a brand, this is probably great for the NFC or for the Minnesota Vikings. They've got the best receiver in the National Football League on their roster right now, and Justin Jefferson, and they're adding a 6 foot, 175-pound Biletnikoff Award winner, which is at the collegiate level, the most outstanding wide receiver. He won this award in 2021. I think he had almost 1,600 yards receiving and something like 17 touchdowns in a season. So the guy is extraordinarily talented and definitely has a penchant for speed. But
let's hope he brings some of it to the field this year and leaves it on and kind of respects the rules of the road a little more. But what I want to know is, how's the dog and what was wrong with Fido? Was Fido in the car? Was there an animal hospital on the way? Oh, to be the judge in that case.
Well, and he apparently, Addison put out a statement sometime very recently and said something to the effect of, it wouldn't happen again. It was a lapse in judgment or whatever, but it didn't, no mention of the dog at all. In
My
his statement.
dog ate the homework, Addison.
Exactly.
Addison. Keep your speed on the field. Keep it off the roads. Those of us who also drive on them depend on your good sense to stay alive. Hey, what's going on? What's
Well,
going on?
before we leave this, we can't forget, you and I covered this story, a similar story, but with obviously very different outcomes. The one of Henry Ruggs. Do you remember the Alabama wide receiver that was drafted
Oh
to,
yeah, yeah.
the Las Vegas Raiders rather, and was speeding down the strip at well over 100 miles per hour, ended up killing someone, and he's now no longer in the league. So I think that the NFL, I'm not sure what they'll do on this. Training camp just started for the Vikings and many teams around the league over the weekend, July 23rd. So that would have been Sunday where everybody reported to training camp. I'm not sure if anything substantial will happen here. The league has taken a really strong stance against things like gambling on games and stuff like that. But this is obviously, it's going to be interesting to see the no harm, no foul, I guess, philosophy from the league on this one. But again, I point to his age, 21 years old, first round draft pick. And I think I saw a clip of him on the Rick Eisen show, which Rick Eisen is a well-known sports personality and anchor, and he was talking about one of the first things Jordan Addison was talking about one of the first things that he was going to do now that he was signed was go and get a nice car. And there was some banter back and forth about, definitely going to drive 65 miles per hour kind of thing. So, it just, it's not as if this couldn't have been foreseen.
The dog made me do it. Well, I guess my question is, was he drinking mail order beer, before he got in the car at 3 o'clock in the morning to do, 140 miles an hour? What's up? Is Congress really considering allowing breweries to use the Postal Service? And is that a good idea or a bad idea?
I don't think that they actually are, but I sent this to you because for two reasons. One, Dave Infante, who writes for VinePair, but also has his own platform called Fingers, which I think is really good. So Dave Infante writes for VinePair. He covers everything beer business.
What is VinePair?
VinePair is a website that covers basically the entire beverage category, right?
Mm-hmm.
And it has a large segment on beverage alcohol. So wine, spirituous liquor, ready to drink cocktails now, and beer. And Dave Infante is someone that I've followed since I began my practice with Carolina Craft Legal. He and I years ago would go back and forth on Twitter, just because the 3-tier system is something of an academic pursuit, and the 3-tier.
Well, so tell us about this. Don't educate us. What is the 3-tier system?
The 3-tier system is simply state to state. It's a way that the government has ordained that beverage alcohol makes its way to market. In other words, it distances suppliers or manufacturers from the end consumer at retail buying through the 3 tiers. So the first tier is beverage manufacturer or supplier. The second is an independent wholesaler tier. So every state has its own demographic of independently licensed wholesalers, and beverage alcohol producers, in order to get their product into the market, are required to use this network of distributors. And
what legal justification is there for that?
So the legal justification ultimately was a combination of things. It was to prevent, first and foremost, it was an antitrust sensibility. So yes. So and you.
I mean, doesn't that give the middleman the antitrust position?
Absolutely, it legislates profits to the distributors, but apparently that is a lesser evil than allowing someone like an AB InBev or a Miller Coors or a Constellation to be able to force downward pressure on the market by buying up real estate and controlling the end user retail experience.
So you're opening my eyes, Mike. Are you telling me that if I'm manufacturing beer, I must use a middleman? I can't sell directly to the end, the retail establishment?
With limited exceptions. So in North Carolina, if you're a brewery, North Carolina has pretty developed for the Southeast region is the preeminent state, flagship state for self-distribution. And so there are limits, in terms of capacity for a small brewery, as it were, to be able to self-distribute, that is, put its own product into the market at retail. But beyond those threshold limits, you must sign those rights over to one or more wholesalers. And here's the other thing about wholesalers: they don't compete with one another. So once a brewery signs its rights to the beer to a certain wholesaler, that wholesaler has those rights forever. And then they also have exclusive territory underneath that franchise agreement, is what they're called, franchise law. And so they are solely responsible for putting the product into an entire retail market in a certain geographical territory. So in North Carolina, usually, there are a number of wholesalers. It's a fairly large state, east to west. And so there are, distributors that will just take up, for example, the greater Charlotte area. And then there are distributors that will take the coast, Wilmington, and so try to get stuff to the Outer Banks and stuff like that. But by and large, these distributors compete with each other to bring brands on into their portfolios, but they have those brands indefinitely. And the thinking there, Norm, not to be too much of a nerd here, the thinking there
you can be too much of a nerd. That's why we're here.
Well, the thinking there is that distributors invest a lot of time and energy and resources, oftentimes in developing the market for that beer to sell. Right. And so for a supplier to be able to, in somewhat of a fickle manner, give notice and terminate arbitrarily, well, the beer wholesaler is not going to be adequately compensated by the fickle nature of a supplier. So there are enumerated ways that suppliers or breweries in this context can terminate, but they're for good cause, right? We're talking about insolvency, fraud, bankruptcy, those sorts of things on the part of
But I'm sure this regime has been challenged legally, and what's the constitutional infrastructure that supports this? This is a valid exercise of the state's police power, or does Congress take it up as some sort of residual prohibition, type of legislation that falls within its implied powers? I mean, I'm a con law guy. I'm looking at this thinking, A, I didn't know anything about it until I met you. And B, it just stinks to high heavens. I mean, we are requiring a costly infrastructure that stands between the consumer and the manufacturer, and that undoubtedly has to have an effect on price.
It absolutely does. And so on the one hand, the 18th Amendment, that was prohibition, federally outlawed the manufacture, sale, transportation, etc., of beverage alcohol products. The 21st Amendment is what repealed the 18th Amendment. And the 21st Amendment left the question of how to regulate all of those categories dealing with beverage alcohol to each individual state. From there, every single state ratified its own version of the three-tier system. And so there are places like Alabama where the three-tier system is still extraordinarily conservative and limiting. And then there are states like Washington in particular that are extraordinarily permissive and liberal with the way that these businesses can get their products to market. So, for example,
could a state opt out of the three-tier system without federal consequence?
Well, by making exceptions to its own three-tier system, it absolutely can. Now, where a state might do so, Norm, but it does not absolve an individual supplier from the federal requirements attendant to its beer. So in this case, I put United States Code 1716F on here, which is essentially saying that beverage alcohol products are injurious articles that may not be introduced into the mail. They're non-mailable for purposes of use of the United States Postal Service. So what breweries have to do in this day and age is take advantage of something like a FedEx or a UPS, some other sort of private common carrier. But even that is imperfect because states necessarily want to know where their products are going. Like in particular, every single state wants to know when a new product has been introduced into its market because there are certain consumer protection issues that need to be vetted, right? So
and also the line between the United States Postal Service and private common carriers is blurred. I mean, you were telling me a story the other day that I think the Postal Service was delivering for Amazon on Sunday at your place or something like that. And so, so if you've got Amazon delivering I don't know if they can, an alcohol product and the Postal Service carrying it, isn't that a violation of the law?
Well, it depends on what state you're in, right?
But this is federal law.
No, I mean, this is, they're speaking specifically to the to the United States Postal Service, right?
Mm,
Not
mm,
being able to use that in federally backed mail. Now, I agree with you. I think that there's an argument now, but Amazon also owns what, Norm? Whole Foods, which is one of
mm.
the largest retail chains in America. And guess who is allowed to direct ship? Retailers. By and
Well,
large,
and also, Mike, here's another thing. I mean, Justin, I'm looking at comments on the YouTube. So curious, what triggered Mike to focus his practice on a niche aspect of the law? Niche aspect, very interesting. I agree, it is, and so here we are dwelling on it. But when back in the day when COVIDtopia had us all afraid to leave the house, we got used to ordering things delivered to the home. And from time to time, we'd call the local liquor store and they'd deliver whatever we wanted. Now, how is that different than going through the mail? I'm still getting an injurious product delivered to me by means of a third party. What's the difference?
well, I think a number of things. Number one, you can't overlook the distributors lobby, right? It's one of the most powerful lobbies. When you start thinking about alcohol, wholesalers as a lobby are extraordinarily strong, right? They're generational businesses. I think I've talked to you about this before. They're legacy businesses. So penetrating that market of wholesalers anywhere in the U.S. is a very difficult task. In fact, one can reason, and I had a conversation years ago with the former CEO of Miller Coors, and his prediction was that distribution and direct to consumer distribution in particular, because that's what we're talking about, direct to consumer, right? What we're just to equalize this for everybody listening, giving a supplier the ability to send a product directly to the end user consumer at their home is skipping the two other tiers, right? Is necessarily affording them the option to skip both the wholesale tier and the retail tier. And the prediction that this gentleman made to me was that when private equity or when venture capital are able to crack in a meaningful way the wholesale or the distribution tier, that is when you will begin to see a shift in the way that are able to get to their end user consumer. From my perspective, I think I don't really know where I fall on this. I think I told you that I've worked with a number of clients trying to solve this problem, and every attempt has been imperfect because number one, there is no standardized mailing option, right? You must use a common carrier like FedEx or whomever else. And FedEx piloted a beverage alcohol system several years back where they were taking on a limited number of suppliers and seeing if they couldn't build out an infrastructure that would afford them the confidence that they were delivering to someone who was of suitable age, right? They were shipping products that were federally compliant with labeling and formula requirements. There are a ton of public policy objectives that lay beneath the surface that the average person might take for granted in this context. But craft beer in particular, I can tell you with confidence that craft beer as a market is an affront to a lot of the things that we take for granted in going to the grocery store and seeing nutritional labeling panels and different having a level of assurance that the products that we're buying have been vetted by the proper federal authorities. And I'm not saying this to slight the craft beverage market. I'm just acknowledging a reality that
Are you saying that those rumors went back before you were born and I was a kid having older people buy liquor for us and then we'd take it out to a parking lot and get hammered? And there used to be rumors that there was formaldehyde in Ripple. So are you saying that we don't really know what's in our craft beer? There could be cow urine?
Well, I mean, the assumption that one should make is that their craft brewery is abiding at least the state standards that are prescribed by law. Now,
Why should we assume that?
well, because it's a requirement, right? Every state has their own regime. Now, I'm saying that in good faith, right? That those that are operating in the beverage alcohol space, we take it on good faith that they are good faith operators, that they are going to abide legal regulations, and at a bare minimum, one can have certain issues with the various finer points and nuances of the way that this business has been regulated at the federal and state levels, but one can't necessarily hold that as a reason for not abiding the basic
Yeah, no, I hear you. I hear you. So we're back. We're back to one of our central core issues. Explaining constitutional issues. So, insofar as states have the police power and traditionally have done so, and the ability to legislate in the interest of health, education, and welfare, they can set standards for craft breweries and others. And so far as a lot of these items are produced and sent in interstate commerce, Congress has intervened as well. And as always with the law, it depends on trust and our ability to assume that others are relying on the law's shadows
Yeah,
as
and I'll
they
leave this
navigate.
for your consideration, Norm. There is a huge reason that those in the beer community are very loud about this issue, and it's because wine has really set the precedent.
Mm,
The wine lobby has really upended what beer experiences in terms of this limitation on getting products to the end user consumer. You can go to Napa Valley and you can order $10,000 worth of wine subscriptions in a weekend and have 200 bottles sent to your home, right?
mm,
And that's no big deal. But that's because the wine lobby has trailblazed this for itself and is a much more mature market in general
mm.
than beer is. And beer is a different product entirely. There are issues of stability of the product. There's also a totally different intelligentsia around wine as compared to beer. Beer has long been viewed as lowbrow, right? And I know that of course, there may be breweries watching this stream that are like, we're not low. And I get that. I'm not making any indictment on any one particular supplier, but I think that in order for beer to actually observe the same sorts of direct consumer shipping laws as wine, there needs to be a more organized and pragmatic presence within the beer community. And right now, the AB InBev and Miller Coors and Constellation, they don't really have a lot of incentive to go and trailblaze a direct to consumer shipping model for basically an army of competitors, right?
So are you up or down on Congress amending 18,
Right now, I
17?
don't. Right
Yeah.
now, if gun to my head, I would say no. I'm not in favor of it, and it's mainly because of the compliance issues that I made reference to earlier. I don't think the beer community is mature and ready enough for that to happen. I also think there are unintended consequences in the form of the Amazon Whole Foods style partnership, where there it might be this 1,000-barrel brewery wants to be able to ship its product here and there to individuals throughout the United States, but ultimately, I think that the consequence of that would likely be much more negative than it would ever be a net positive. So for now, I'm still a no, and I could be changed, and I just don't, I'm much more sober to this issue than I think many beer fans might be.
No pun intended there. Let's shift to newspapers. Justin gives us a nice transition. Good morning, Justin Carduck. Good to see you again. Newspapers today, a more dangerous product for the public than alcohol, has no delivery issues, no red tape. Well, that could change. Jonathan Turley had an interesting story. I think it was published last week about whether there's a growing appetite within the legacy media, what some call the mainstream media, the New York Times and others, to create an exception to freedom, to the doctrine of free speech on the grounds that misinformation is harmful to the public. And so, we've talked on this stream, Mike, about whether there'd be a hate speech exception, and predicted that there soon will be litigation in front of the Supreme Court. I would expect within the next 3 to 7 years, there'll be a case that will argue that hate speech that is designed to express hatred, is designed to heap scorn on a class of people or a set of ideals or a religion or those who hold the religion, that speech will be regulated insofar there'll be a push to regulate it on the grounds that it's injurious to the public welfare, and that much like pornography. If it lacks any serious scientific, literary, artistic, or value, and appeals simply to prurient interest, that is, lustful interest, it can be regulated under community standards, and outlawed. And Justice Potter Stewart once said of pornography, he'd know it when he saw it. The Orwellian segment of the pod. Well, here we go.
More than conservative.
I'm glad you're listening. But I think that I foresee a case that will say that class of speech that lacks scientific, literary, artistic, or political value, expresses simply hatred, can be regulated in the name of the public interest. Now, having said that, what people hate what people are opposed to often defines their political identity. And so you come right to the very line of the core of those issues the First Amendment protected, that is political speech, alternative visions of the public good and man's place in the universe, and so forth. The misinformation claim that Turley's making, or discerning rather, is a little more chilling and yet more intuitively understandable. So, for example, I've been listening to Robert F. Kennedy Jr.'s book on Fauci. And I'm also reading a book my wife gave me actually last Christmas. I'm finally getting around to it. She gives me so many books, it takes me a year to get through them, on the rise of the Sackler empire and the opioid manufacturer, Purdue Pharma. And so there is a view of the universe that is that the best means of knowing things and knowing how to improve the public welfare is science, and that a scientific consensus should govern public policy in areas of critical importance to public health, such as COVID. And so along comes a guy like Robert F. Kennedy saying, wait a minute, let's not accept uncritically what we were taught in the COVID era. There were institutional interests that were very much behind the development of the vaccine, and these were large pharmaceutical companies, and they had a real interest in suppressing alternative means of treating the symptoms and preventing the spread of COVID, because under FDA regulations, that is Federal Food and Drug Administration regulations, vaccines could not receive expedited approval if there was an efficacious treatment in the market. In other words, a vaccine can be rushed through the approval process on an emergency basis. And one proof of the emergency is there is no other means of treatment. So Kennedy raises questions about whether Big Pharma suppressed scientific studies and information about ivermectin or about hydroxychloroquine in order to destroy any perception that they had efficacy and to hold open the highly lucrative market for vaccines. It's an interesting argument. I lack the ability to place it in any critical perspective because I'm simply reading it, but I'm or listening to it, I should say. And I should say to Robert F. Kennedy, if you're listening, which I doubt, or if somebody knows, if somebody who knows him is listening, tell him to drop the adjectives. Tell a story without dropping the corrupt Dr. Fauci, the venal this, the horrible that, the shocking this. Just give us information. Trust us to reach the right conclusions. Save the editorial judgments for an argument that is supported by a well-reasoned assessment of facts. It may be that Big Pharma overestimated or underestimated and attacked treatments that had efficacy and ignored and demonized the hundreds of scientists who supported ivermectin and hydroxychloroquine. That's a story that I think we want to know. But I think, as Turley points out, there is now a claim in COVID and the COVID and the reaction to COVID vaccines is the test case that if you are an outlier in this debate and you're spreading misinformation, which from the mainstream media's perspective or the scientific consensus, if you're doing that, you're spreading misinformation, even if you genuinely believe it. And if you genuinely believe something that the establishment considers to be wrong, you're harming the public. And wouldn't that, by analogy, be the same thing as hate speech? And by a double analogy, be the functional equivalent of pornography or something that lacks any serious scientific value and can harm the public? And he's seeing signs in the New York Times editorial boards and elsewhere of a tolerance for a First Amendment exception to misinformation. And you need look no further than the Fifth Circuit, United States Court of Appeals for the Fifth Circuit, and the case involving the Biden administration's cooperation with social media to suppress certain information. Initially, a trial court judge issued a temporary restraining order prohibiting the Biden administration from reaching out to social media companies to take down or suppress certain forms of information. The court said, wait a minute, that's entangling the government with private enterprise in a way that is suppressing freedom of speech. And he enjoined the president and others. The Biden administration went to the Fifth Circuit Court of Appeals seeking an emergency stay, saying, but wait, We are custodians and caretakers of the public good, and preventing us rather, even on a short-term basis, from suppressing harmful ideas is injurious to the public good. The Fifth Circuit granted the stay, which shocks me. In form, it's a substantively shocking order. The case will undoubtedly be briefed and argued on an expedited basis in the Fifth Circuit, and is likely to head to the United States Supreme Court, where we might just see the first real test of a misinformation exception to the First Amendment. And I'm not sure what the standard would look like, Mike, for application of that.
Well, I mean, I'm not so old as to forget being in law school and in my First Amendment class, because I'm not sure if you had the same experience, Norm, but I had
When I was in law school, we were studying the foundation of the Roman Republic. The American Republic hadn't yet come into existence.
Well, all I meant to say was that, we had constitutional law as its own doctrinal course, but then we had a separate First Amendment course requirement. And I remember distinctly being in class on the day that we began a conversation about, the pursuit of truth, and then what is truth, and how are we to determine truth from falsity, and that the law had evolved to accommodate all speech, right, within those narrow exceptions that we've defined previously on this podcast, but aren't really relevant for purposes here. But that seems to be the age-old question: is how are we to define truth, and how are we to categorically recognize misinformation or falsities? And I'm remiss if I don't bring up the fact that the emergency use authorization was the premier purpose by which the shots were ratified, right, where they were brought into the market. It was pursuant to this emergency use authorization, a creature of federal law, that essentially allows there to be circumstances by which medical authorities can point to and say there are no other available means by which to combat this public health crisis, and we will suspend scrutiny that we would otherwise apply to these things in furtherance of a public good. The issue that we are really tangling with now, as it relates to misinformation in that context, is the fact that there was a populist recognition that there were items within our control and custody that could have supplanted the need for a widespread rollout of a medical procedure that was branded as the only way to protect us against, a public health crisis. That is, I guess, the most sinister part of all of this, is that we have left all of that behind, right? The, censorship on all major social media platforms, Joe Rogan, when he hosted certain personalities and certain scientists within that context, he was censored. CNN, altered his appearance because he opted to go with an alternative treatment. They altered his appearance to make him look sick, right, in the public mind, to prop up that belief that these alternative methods of treatment were, not good. I think that, I don't know that misinformation can really ever be categorized as an exception to speech, but this does define the power of big tech right now, that people are even led to believe that there are our cultural betters, that we have institutions that could do so in a way that wouldn't at some point come home and damage them in a way that they are not comfortable with, right?
Yeah, I hear you. I mean, all I know is it's an issue that I'm only now starting to pay attention to. I've never been candidly, I'm a believe the science kind of guy. I got the vaccine because my wife, who is very, very smart and intelligent, studies this stuff. She wanted me to do it. So, like, okay, if it's good enough for her, it's good enough for me. But when I look back now and I read through the emerging literature about and discussion of big pharma's control over its market, I begin to suspect the same sort of venal market control that beer distributors, what the middlemen have, with respect to controlling the distribution of something very much in demand. Or when I consider, like, one of the things I didn't realize about the Sacklers, who created Oxy through Purdue Pharma, is they were at the forefront of the psychopharmacological revolution. That is, with respect to the treatment of mental illness. For a time, it was thought perhaps that environmental factors created the mentally ill, or in the alternative, that people were just born with bad genes, so to speak, even before genetics were widely accepted,
and that would fix it, right?
Yeah, or lobotomy. So they engaged in the psychopharmacological gamble and made a fortune in Librium and Valium, and then turned that money into the treatment of another ubiquitous human problem, pain, and succeeded wildly beyond their imagination, their wildest dreams. And of course, we're now dealing with the consequences of that. So big pharma, is a force to be reckoned with in our lives. And I think that Kennedy is raising interesting questions. And when I see Klaus Schwab and others talking about the need to prepare for the next pandemic, which is coming sooner than we think, I don't go to the conspiratorial world and say, well, they're going to feed us one, as it were. But I do raise our common preoccupation, Mike, with the scope of the public health state and who decides what's in our welfare. And I think it's an enduring and continuing problem in any collective, in the experiment of collective life, that someone has to. And if we leave it to our individuals to decide and they opt out of a vaccination regime, the vaccine is less effective. On the other hand, if there are effective ways of treating beyond the vaccine, and pharmacological companies have an incentive to discredit them so as they can bring their monopolized product to market at great profit, without fear of consequence, because Congress indemnified them or exempted them from litigation for the outliers who suffer as a result of the vaccines. That's problematic too.
Well,
that's problematic too.
Yeah, and that's RFK's major platform. I did put the New York Times article on the screen a few minutes ago, but it's interesting to just read that article, and I'll see if I can bring it up. I brought it up through removepaywall.com, but this is by Cheryl Gay Stolberg, who Turley references in his article that was previously on the screen. But it's interesting the way that she describes Mr. Kennedy. Mr. Kennedy, an environmental lawyer who turned into anti-vaccine activism and has trafficked in conspiracy theories, right? That's a prefatory statement to say something completely different about what he was testifying before Congress about. But if you have listened to RFK on any podcast or anything where there's been a long form discussion, he talks about the anatomy of the current sort of administrative bureaucratic state, public health state. And this is something that you and I have talked about, it being a growing concern for us, is the emergence of this rail that is the public health state as we know it. And but what is crucial to this is just recognizing that anybody, even if he's a rogue adjective user, but anybody in RFK's position who knows as much as he does is in a manner similar to how I know the regulatory framework for the regulation of beverage alcohol across the U.S. and in individual states. Anybody who understands how these apparatuses function is going to tell you, hey, yeah, there is obviously a profit motive in discrediting competition. That's just the way that it works. Right.
Yeah.
If there are any sort of federal safe harbors, as we'll call it, that give these companies immunity from liability, or allow them to do certain things in a development and bringing it to market, or if there aren't accountability measures that have any sort of efficacy on the back end to track, whether they said, what they said was going to happen is indeed happening, or if it is being administered and the way that's being administered. I mean, this is just, very, I guess, rote level stuff that's that I think people have questions about now, but it's being turned into this sort of I guess wanton cynicism and conspiracy peddling if one questions it with reason the way that you just did.
Well, I think that the book I'm referring to, and I'd ask others of you to take a look at it. I'm listening to it, and I think I'm going to need to get a hard copy of it because there have to be footnotes. It's called "The Real Anthony Fauci" by Robert F. Kennedy Jr. And the thing that is stunning about it, forget the adjectives. That makes for annoying listening. But he spends a great deal of time talking about the number of dissenters within the scientific and medical community who published studies and were demonized and ostracized as a result of that. And the politics of that demonization and ostracization, to my mind, is where the action is in that book. Again, it's called "The Real Anthony Fauci" by Robert F. Kennedy Jr. I recommend it to all of you. I'm not saying, accept what he's selling, hook, line, and sinker. I'm saying critically appraise it because he's raising serious questions that I think need to be addressed in the context of a constitutional commitment to liberty, to efficacy, to the ability to choose your own course in life. So there we had it. Oh, I guess, are we going to braise another topic?
We can just briefly introduce this. We don't have to talk about it today, but for anybody who wants to get a jump on tomorrow, we will cover this. It's in the Wall Street Journal. It's called The Rise and Fall of the Chief Diversity Officer.
Great article.
Yeah, disappeared July 21. And I think they actually have this freely available. So you won't have to get behind a paywall or use some alternative to read the article. So I guess this is homework for LA aliens this morning is read this. We'll come back tomorrow and we'll talk about the collapse of the CDO, right? And we're not talking about The Big Short. Where'd Norm go? Am I still here? Hello? Am I still live? I have to be live. Someone type in the chat and just let me know that I'm still here and I'm not talking into the... Okay, thank you, Hans. So maybe it's Norm. Anyway, I'll take this off the screen. And there he went. Okay, cool. Well, look, we're going to get out of here. We're live on Twitter /X or X/Twitter or X Twitter. Here comes Norm.
Well, yeah, so the rise and fall of the DEI diversity officer might be an example of what we talked about, the woke project collapsing on itself. How much of this can we accept before it becomes an exercise in absurdity? And the answer from the C-suite is we might have hit the vanishing point, and DEI officers may be vanishing. Good riddance, nothing to mourn there, but we'll talk about that tomorrow.
Yeah, we should. I definitely want to get into the substance of that, because I think that the article itself starts to get at some of the natural questions I had before beginning the article, which is, how is this different from normal HR departments? When did the rise in these positions begin? How are they even filling these positions, and on what criteria, and to what logical end? And then if you're like me and you work in the business transactional world, from a legal perspective, it's just interesting to try and understand how someone in a CDO position actually affects the product or services that a company is producing, and how, if at all, they are not just anything except a cost center to the business. So anyway, we'll talk about that stuff tomorrow. Norm, thanks for jumping back in. You were making me feel crazy there for a second, because I didn't know if it was me or if it was you, but then our chat made me feel okay that I was still here.
Mike, nobody can make you feel crazy. You just came out of the womb that way. Thanks for listening, folks. We'll be back tomorrow. Mike, how do people find us?
You can find us on YouTube Live, Rumble Video, and also on X/Twitter every day, 8 a.m. Monday through Friday, except on days when I come down with bronchitis or something similar to that. But we'll try to, as much as possible, we'll try to give you notice when that stuff does occur. On Apple Podcasts, Spotify, Google Play, Overcast, Audible, etc. You can find us there as well. If you're unable to view us live or otherwise don't want to come by way of the video, leave us 5 stars if you're over there. And yeah, you can find us on Locals as well. Consider becoming a Locals member. But Norm, we've got a lot this week transpiring. Cool. I'm looking forward to knocking this out.
Me too. Talk to you all tomorrow.
All right, bye.